Yes, Juan de la Cruz is qualified for probation or for applying the probation in accordance with the probation law of 1976 Presidential Decree of number 968 that stated all persons are sentenced for a crime are qualified for probation except those who sentenced to serve a maximum of imprisonment more than 6 years, then second, convicted of subversion or crime against national security or public order. Then the third is who have previously been convicted by imprisonment of not less than 1 month and 1 day and a fine of not less than 200 pesos. Then fourth is who have been once on probation under the provisions of this decree, and fifth is who have already serving his sentence at the time that substantive provision of this decree became applicable pursuant hereof in section 33. Then it means that Juan de la Cruz his sentence is 3 years to maximum of 6 years. So his sentences does not exceed in 6 years and 1 day, so he can be qualified for the probation that guaranteed by the court.
According to Presidential Decree number 968, or what we call Probation Law of 1976, probation is a kind of privilege in which those offenders who are qualified to take this kind of privilege is not sent to prison by sentencing court. Instead, the convicted person is released and placed under the supervision of a probation officer subject to the conditions which the court may impose. But there are people who are not qualified to avail this kind of privilege. According to the law, those offenders or people who are not qualified to take this kind of privilege are those who are sentenced to serve a maximum term of imprisonment of more than 6 years, those who are convicted of subversion or any crime against national security or public order, those who have previously been convicted by imprisonment of not less than 1 month and 1 day, and a fine of not less than 200 pesos, who have been once in probation under the provision of this decree, and those who are already serving sentence at the time that substantive provisions of the decree became applicable pursuant to section 33 thereof. In general, Juan de la Cruz, who was found committed drug pushing under RA 9165, is not qualified to avail probation because according to the law, his penalty of being pusher is ranging from 12 years and 1 day to 20 years and a fine ranging from 12,000 to 20,000.
If ever the violation of Juan de la Cruz was found committed under RA 9165 is drug pushing, will your answer will change, justified. If Mr. Juan de la Cruz was found guilty in violating the Section 4 of RA 9165 for drug pushing, he will be sentenced with 12 years and 1 day to 20 years of imprisonment. He will be automatically denied of his request to have a probation, since it is stated that the person can be qualified to avail this kind of privilege if he or she is sentenced to serve a maximum term of imprisonment of less than 6 years, and Mr. Juan de la Cruz exceeds this quota, making him miss the privilege to avail probation.
Juan de la Cruz, as first-time offender under RA 9165, can appeal to Court of Appeals to reduce the sentence of his case, but he is also qualified for imprisonment for 4 years to 8 years. Under this act, even the sentence provided, the higher than the provided under existing law on probation. In this case, Board of Pardons and Parole and Probation Probation Administration. The board shall submit written document or written report for determination. Even though Court of Appeals also have the power to try cases and conduct hearings, Juan de la Cruz cannot be disqualified for the probation as first-time offender, and the Court of Appeals should resolve the factual issues.
If Juan de la Cruz is a first-time offender, he violated Section 11 or 15 of the Act, but not more than 18 years of age at the time he is found guilty of the said offense. Under Section 11, Privilege of Suspended Sentence. If user may only enjoy privilege of a suspended sentence once, and under Section 15, return of the offender to court. If the explanation of the offender is not satisfactory, the executive director shall petition the court to lift the order of suspension and to order the offender to serve his sentence as any other convicted person.
If ever Juan de la Cruz was sentenced for the effectivity of RA 10707, is he qualified to privilege of probation law? Yes, I think Juan de la Cruz is qualified on probation law because even if the RA 10707 is not effective yet, there is still the PD 968 which is effective to serve as his legal basis to have a probation. RA 10707 is just an amendment of PD 968, so it means that the PD 968 is still effective even if the RA 10707 is not effective yet. Especially, he is a first-time offender, did not commit a crime against national security, and have a penalty not more than maximum term of 6 years. What are the implications of RA 10707 to Juan de la Cruz application for probation if ever it is still pending for court decision? If ever that Juan de la Cruz application is still pending for court decision, the implication of RA 10707 is that he can't be subjected to suspend the execution of the sentence and place the defendant on probation for such period and upon such terms and conditions as it may deem best because the court is still undecided.
If ever that Juan de la Cruz was sentenced before the effectivity of RA 10707, which is the amendment of the PD 968, he is still not be qualified to apply for probation. Because as we can see, according to the section 9 of PD 968, which indicates the disqualified offenders, the benefits of this decree shall not be extended to those who are already serving sentence at the time of substantive provision of this decree become applicable pursuant to section 23 thereof. And in case that court decision is still pending for the application of Juan de la Cruz for probation, the possible implication of RA 10707, the trial court shall suspend the execution of the sentence imposed in the judgment.